seated. The records reflect we're outside the presence of the jury. Present, including the defendant. So let's take a little time this afternoon while we have some time. We're sending the jury home early, but I'm not going to send you all home early. So we'll take advantage of this time to talk about jury instructions. If you all get a moment to bring them up on your computers. Instructions. These aren't the most riveting topics. These are the instructions that I'll be giving the jury tomorrow if we do instruct them tomorrow. If anybody wants to escape at this point, feel free to do so. You won't be offending me if you leave, but you're more than welcome to stay, obviously. Instructions that they submitted a while back. First paragraph, is there any objection? First paragraph.
Judge, as we're going through these, I'll maybe to make the record clear, I stand by our objections that the requested redactions we had on our proposed penalty phase jury instructions. Having the court make your decision as to those objections, we'll stand by those as we go through this. I don't want to say anything in case I'm waiving anything from you.
Okay, let's do this. I'll note a standing objection to the instructions as a whole, based upon what you earlier submitted, which are the redactions and additions and so forth.
Yes,
but then I'll understand if you don't say you don't have an objection to a couple of paragraphs in here, or all paragraphs for that matter, you're not waiving your earlier objections because you have a standing objection to the instructions as a whole. All right. Other than the standing objection, any objection to the first paragraph?
No, you don't.
All right. The second paragraph is called the Hurst v. Florida paragraph. That the jury has to make a unanimous determination as to each aggravating factor alleged by the state, and they have to determine that beyond a reasonable doubt, and then defines in general an aggravating factor. Any objections other than those previously noted to that paragraph?
No.
All right, then the state goes through the aggravating factors for count one. The first one listed is the prior conviction of another capital felony or felony involving use or threat of violence to another person. It then goes on to state that first-degree murder is a capital felony, referencing, without saying that, the contemporaneous conviction for first-degree murder in count two. And then also goes on to say the crime of attempted first-degree murder is a felony involving the use or threat of violence to another person, referencing, without stating it, the convictions of the jury's findings appealed as to counts 3 and 4 of the indictment. So any objection to that other than those previously noted?
No.
The next aggravating factor is what's listed is that what is known as the felony murder aggravating factor, which reads the first-degree murder was committed by James Terry Colley Jr. While he was engaged in the commission of a burglary. Any objection to that?
No, Your Honor. And again, of course, with all these aggravating factors, we previously submitted motions that they, as to their constitutionality as well as applicability in this case. Do we stand on this?
Correct. So all those objections remain as standing objections. The third aggravating factor listed is the heinous, atrocious, and cruel aggravating factor. Starts off with the first-degree murder was especially heinous, atrocious, or cruel. Then defines the term heinous, defines the term atrocious, and defines the term cruel. Other than previously noted objections, are there any objections from the defense?
None other than previously stated.
So noted. If anybody identifies any typos or anything in here, let me know. The fourth aggravating factor asserted by the state with regards to the first count of the indictment is cold calculated, premeditated. First sentence reads, first-degree murder. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. It then goes on to define cold, calculated, and premeditated in the context of that aggravating factor. Is there any objection from the defense other than those previously noted?
Yes, actually, Judge, I do want to go into more detail on this particular aggravating factor because, Judge, we're going to ask, I am asking, that this aggravating factor not even be given as to either count in this case. There's been simply, this aggravating circumstance has to require, or does require, as it's stated, a heightened level of premeditation demonstrated by a substantial period of reflection. There's been no testimony we submit from the state through any witness in this case that Mr. Colley, in committing the homicides, had or acted after a heightened level of premeditation. The jury, taking everything that the state has presented in the light most favorable to the state, as you would in a JOA proceeding, this is a case where you've had a lot of testimony that despite the injunction, the parties are around each other, had contact with one another in the days immediately preceding the homicides, that it wasn't until, and I think the state's narrowed this down to the morning of August the 27th, that during contact with Ms. Colley, that there was a reaction from Mr. Colley based upon some information about the police being involved or responding to the break-in that occurred earlier in the morning. Nothing that was presented during that time period, as well as the minutes, the hour or so after that exchange or conversation, shows a heightened level of premeditation. Even if you take the evidence that the state's presented, Mr. Colley becomes armed and goes to the house, and then, according to what was reported through the experts, sees a man, has apparently a panic attack or has a reaction to seeing the man, and then within minutes the shooting occurs and he goes inside the house, and unfortunately 2 people were shot and killed in there. Under my recollection of case law, none of that shows a heightened level of premeditation as you would in a situation like a contract murder case, or where there was some drawn-out, planned attack that led to someone's death. All the evidence shows that there was a reaction from Mr. Colley, that, again, taking what the evidence the state has presented, that he was in a state of anger, and it occurred, what happened occurred. Even in the presentation of the evidence, we don't know, although the jury has found that certainly there was premeditation here, and the court's well aware of the standard for what is considered to be premeditation under the law. When did, if you take the state's evidence in their favor, when did Mr. Colley, or when was it proven that Mr. Colley formed the intent to kill 2 people? You heard the evidence about what happened inside the house and the reactions that Mr. Colley had. None of that shows any heightened premeditation. So as I understand the case law, I've done a great deal of research on this, if there's no evidence that would support the state's theory, the state should not be entitled to present this particular aggravating circumstance either as to count 1 or count 2 of this indictment. And I would ask the court to not allow the jury to be instructed on what we call CCP.
Do you have any case law to cite that under these particular circumstances, the CCP instruction would be inappropriate?
Well, actually, I was, right now I do not. I'm going to do some research tonight, Judge, and I promise I'll have a better informed decision on that later on tonight. We had a long day yesterday, and certain things have come to mind or to raise during the course of today's proceedings. But given that we had a deposition after closing yesterday and some other things going on, I'll take a look at that. But and I've done in a prior case, I remember making the argument with regard to this in a prior death penalty case. So let me follow that with some additional case law. But that's the argument I make as to the instructing the jury on that fact.
I'll surely entertain it after we've had a chance to do some research. But let me hear from the state with regards to the CCP instruction.
Thank you, Your Honor. I think the evidence in this particular case is plethora. What we have presented during the course of the trial, Judge, is that the defendant and his wife were going through a difficult time. They went through a divorce. Mr. Colley, the defendant, suspected that his wife was having an affair. There were many text messages, phone calls, where he clearly communicated that he was upset about this. And then we have the night before this occurred, on August the 26th of 2015, he breaks into his wife's home. He finds items within the home that he believes confirm his suspicions that his wife is having an affair. He becomes extremely angry. He breaks breaks 3 TVs in the home in a fit of anger. He takes the items from the home. He goes directly over to his neighbor, his friend. He's pointing out these items, telling him he's found the evidence. He's, again, very angry at that time. He goes to court, which had to do with his wife, a violation of injunction in that particular case. There's other phone conversations, voicemails left, where he is screaming at his wife, telling her that she's lucky that he doesn't tell the kids about what he found, and he says that she's, excuse my French, but she's fucking disgusting. Clearly demonstrating his anger, his hatred. We heard evidence that he literally had his wife logged into his phone as quote-unquote bitch. He then leaves court. He has a conversation with his wife on the way there where she tells him that after he basically told her what he had done breaking into her house, she essentially told him that the cops had been called, and as we heard testimony of the last couple of days, told him that it wasn't her that called him. It was clear references that it was Mr. Dubberly that had called the police. This made the defendant very angry. He doesn't go directly to Miss Colley's home. He goes all the way up to Garrison Drive, which is north. If you're leaving the courthouse, it's north of Miss Colley's residence in Mirabella. Goes to his home. There's evidence, photographs where he went to his home. He gets guns from his home. He gets ammunition from his home. We heard essentially what we refer to as a butt dial voicemail, where you hear where he's rustling through. You hear someone in the background, likely his father, saying he's an idiot. We heard a testimony from Brittany Mano that she overheard the defendant's father prior to the murder pleading with his son not to do this. And we also heard testimony from Detective Tolbert that the distance between the defendant's home on Garrison Drive to the Mirabella residence was approximately 15 miles. And then he goes to the home. He doesn't go drive into the driveway. He drives into the neighborhood behind the residence, essentially sneaks up from behind, and that's when he begins shooting into the residence. We heard the 911 calls when he enters the home. Where is he? Where is he? Where is he? We hear on the 911 calls Amanda Colley pleading for her life, put the gun down, put the gun down. We hear Ms. Colley telling him, as he's saying, where is he? No, that's Rachel and Lindy in the closet. We hear him shoot Ms. Colley. We hear him shoot into the closet. We hear him shoot Lindy Dobbins. We hear him come back. He didn't kill Amanda Colley the first time. We hear after he executed Lindy Dobbins, he comes back and shoots and essentially finishes off Amanda Colley before he then makes his flight from the jurisdiction. So that's in just a nutshell, Your Honor. When we're talking about premeditation, we talk about how there has to be an intent that's formed prior to the act of killing, and there has to be sufficient time for reflection, but that time can be very short. In this particular setting of CCP, obviously there has to be heightened premeditation. And here we see this whole situation, it begins to build in the days and in the night before. It begins to build and build and build. And there's a culmination where the defendant makes that decision that he is going what he's going to do. He goes to his home. He gets not one gun, but he gets two guns. He gets ammunition, and then makes that 15-mile journey from his home to Amanda Colley's residence, where he shoots and kills her. And again, as I said, he didn't get her the first time. He shot her, shot the friend, and then came back and finished Amanda Colley off. I don't think there's any question, Judge, that in terms of this question of whether or not the jury gets to hear the instructions on CCP, that there's sufficient evidence to support that.
As it stands now, there are currently two versions of events out there. One is that the defendant went to the Bellagio home, walked towards the back of the home, saw what was going on inside, then went back to was angered, went back to the car, armed himself with guns, came back and proceeded to engage in the events that brought us here. The other version of events that the jury likewise could conclude took place was that the defendant left court, went to the Garrison address. We know there that he at least got ammunition. There's some, I guess, conflict as to whether both guns were in the car already or not. Maybe one, maybe both, but got some ammunition. Clearly there's evidence out there where a jury could conclude that at that point, at least at that point, he was intending to commit a murder at the Bellagio address. He then drove, as the state noted, approximately 15 miles, surreptitiously parked his vehicle on a different street at an abandoned home, and then at some point armed himself with the two firearms and then committed the offenses at issue. So there is at least sufficient evidence, as far as I'm concerned, that there was a substantial period of reflection to give rise to a heightened level of premeditation that a jury could find. So as it stands right now, I will give the CCP instruction. However, Mr. Wood, if you find some law to the contrary, I'm always open to hearing that, and we can address that tomorrow if you find something to the contrary.
Yes, sir. I will bring my trusted laptop home.
Okay.
All right. Speaking of that, before we move forward, though, Judge, again on this, as part two of my argument, I don't know if you've seen it or not, but on Sunday evening, I e-filed an objection to the definition of premeditation that's contained in the CCP instruction. It is the same argument that I made with regard to the definition of premeditation contained in the first-degree murder instructions for the guilt phase. I've inserted that verbatim into the objection, and the grounds are for the same as I did previously in the guilt phase. Since there is the definition, although it's actually just one paragraph in the CCP instruction as to premeditation, in the first-degree murder premeditation instruction, it's actually two paragraphs. But nevertheless, I felt compelled to make sure we're consistent on our argument, and we inserted the requested premeditation language for that particular aggravating circumstance.
Thank you for bringing that to my attention. I'm going to give the instruction promulgated by the Florida Supreme Court, which is the instruction that we currently have before us. So I'll deny the request for the special instruction in regards to premeditation. Moving on to the fifth aggravating circumstance asserted by the state as it pertains to count one of the indictment. is that the first-degree murder was committed by a person subject to a domestic violence injunction issued by a Florida judge, and the victim of the first-degree murder was the person who obtained the injunction. Other than the objections previously stated, are there any objections to that?
No additional objections.
Okay. Then with regards to count 2 of the indictment, the first 4 aggravating factors are restated. That would be the prior felony conviction or prior capital felony conviction or felony involving threat or violence, felony murder, HAC, and CCP. Other than the objections previously stated, are there any additional objections?
No, Your Honor, and also to just want to make sure that the record is clear on this, I request for the premeditation instruction that obviously applies to both aggravating circumstances in this instruction.
Right, so noted. Then there's the instruction about victim impact, which I already gave to the jury prior to each victim impact statement being read.
Yes,
I would give that again. Is there any objection to that?
No, Your Honor.
The next paragraph, now on page 4 of 11, discusses the state's burden of proof, which establishes the existence of each aggravating factor beyond a reasonable doubt, and then goes into the definition of reasonable doubt as it pertains to aggravating factors. That's that paragraph. That's 2 paragraphs. The last 2 paragraphs on page 4. Any objection other than those previously noted?
No new objection, Your Honor.
The first 2 paragraphs currently on page 5, again, state that the jury's finding as to an aggravating factor must be unanimous and must be proved beyond a reasonable doubt. Other than the previously stated objections, any objections to those first 2 paragraphs?
No, Your Honor.
All right, the next paragraph, the 3rd paragraph on page 5, also speaks to the requirement of unanimity of the aggravating factors proven beyond a reasonable doubt, and also asks the jury to make the additional finding to determine whether the aggravating factors are sufficient for a determination that the death penalty was better off reading it into the record and trying to paraphrase it. If, however, you unanimously find that one or more aggravating factors have been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must make additional findings to determine whether the appropriate sentence to be imposed is life imprisonment without the possibility of parole or death. Any objection to that other than those previously stated?
No new objection, Your Honor.
All right, the next paragraph on page 4, continuing on to the bottom paragraph on page 5, talks about mitigating circumstances, defines mitigating circumstances, and explains to the jury that it does not need to be unanimous and does not need to be proved beyond a reasonable doubt, but only by the greater weight of the evidence. Are there any objections to those 2 paragraphs?
None other than previously stated.
Then beginning on page 6 of 11, going through page 7 of 11, there are 23 proposed mitigating circumstances set forth by the defense. I'll first go to the state on that. Does the state have any argument or objections to any of the 23?
I'm just scanning through, Judge, real quick. It looks like there's been at least some evidence as to each of these, Judge.
Okay. And the 23rd is the cash offer?
Yes, sir.
All right. Anything further from the defense on that? Are there any additionals that the defense wants?
Yes, Judge, there is one. Thank you for reminding me about that. I would like to, and this has been discussed through testimony, I'd like to add, it's a little more specific than number 19, that the defendant had been previously diagnosed for depression.
Any objection to that? Any preference, Mr. Wood, as to where you want that in the sequence? Where do you have a preference?
Can we put it after 19?
All right, that'll become number 20. Read this way, Mr. Wood. James Terry Colley Jr. had previously been diagnosed with depression, period.
Yes.
You're okay with that?
Yes. No, Judge, I don't think you were asking. I don't have anything else other than that to add.
Okay. You were chatting with your client. I just want to make sure that you didn't have anything further on that before I went any further. Okay, thank you.
Judge Jones, if we could go back to page 6, very small, grammar typo, number 13. That should be loved.
I think I pointed that out before doing this.
Oh.
When at some point, but yeah, we'll make that change.
Mine says loves, maybe I
Yours says
changed it
loves.
when you said it, but I don't know that it ever made sense.
Okay, that may be, I'm working off the original copy.
So love.
Any other typos? Maybe we should read through again. I don't see any other typos. All right, going to the bottom of page 7 to the top of page 8 is the weighing process, where the jury is asked to weigh the aggravating factors against the mitigating circumstances. Other than previously stated objections, are there any objections?
No.
All right, the second paragraph on page 11 is, we'll call that the Hersey State paragraph, not the Hersey, Florida, but it's the Supreme Court decision, which reads as follows: you'll provide a form to reflect your findings and decision regarding the appropriate sentence. If your vote on the appropriate sentence is less than unanimous, the defendant would be sentenced to life imprisonment without the possibility of parole. And it goes on in the next sentence to talk about balloting and how to do so.
I'm sorry.
I'm sorry.
I missed a word. Talks about what and how to do
Balloting.
so. Balloting, okay.
And how to go about doing that. Any objections other than those previously stated to those two paragraphs?
No, Your Honor, and then I guess I should just, in passing, mention that, or for the benefit of the record, mention, of course, that we did have a separate pleading, a motion requesting that the instructors not instruct the jury about the requirement of unanimity for the death penalty for the arguments that we made in that prior pleading. The court had entered an order denying that pleading motion. So, but other than previously stated, we have no additional objection.
Okay. All right, then we get into the jury's consideration of the evidence and testimony, beginning on page 11, excuse me, page 8 of 11, going to page 9 of 11. The state had included in there originally, and it seems to be appropriate, whether the witness was offered or received any money in preferred treatment or benefit in order to get the witness to testify. There has been testimony on both sides that some of these expert witnesses have been paid. That would appear to be appropriate. Does everybody agree?
Yes, sir.
All right. And then number 7, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? There has been some of that. There have been a lot of depositions showed to witnesses, so it would seem to be appropriate that that should be given. Does everybody agree?
Yes, sir.
All right, on the bottom of page 9 is the paragraph about the defendant not testifying. I think we can make one change in there about his decision. Right now, his or her decision.
Yes.
You'd be corrected as to his decision, but other than that, since the defendant did not testify, and other than any previously raised objections, are there any objections to that paragraph?
No, yes, sir.
Then beginning on page 10 of 11, there are rules for deliberation, 1 through 5. Any objections to that other than those previously stated?
No, Your Honor.
Then it tells the jury they'll be taken to the jury room, and the appropriate form will be given to them. I will go over the verdict form with them. It doesn't have as it does with the guilt phase instructions, a portion where it says read verdict form, but I would read the verdict form and go over the verdict form with the jury. That's the point. Does anybody have any objection to me doing that, or any objection to that paragraph?
There you go.
The rest of that page talks about the jury not communicating with anybody else and not taking their phones back. This is the page 10, bottom of page 10. Other than objections previously stated, are there any objections to that?
There you go.
All right. And then page 11, again, our final instructions about not contacting anybody. Looking at the evidence, the fact that the court cannot participate in deliberations, and if they have any questions, to give us a note like they did before, and that they have to follow the law. Any objections other than those previously stated?
There you go.
Okay. And I will give the instructions after your closing arguments in the penalty phase. There is no option to give it before closing arguments in the penalty phase in the standard jury instructions. Let's talk about the verdict forms. If you can get those out, there's a verdict form, separate verdict form for count 1 and count 2.
Judge, I don't have an extra copy with me right now. This was you're referring to the same one that was proposed or submitted by the state?
Right.
Okay.
Do you not have it with you?
I can pull it up.
I can put it on the screen if you want.
If you can, that'd be great. Otherwise, I'll just take it a moment and pull it up on the e-form. Thank you.
All right, this tracks the most recent verdict form promulgated by the Florida Supreme Court as of March 24 of this year. Starts off with Section A, aggravating factors. It starts off by, we, the jury, unanimously find the state has established beyond a reasonable doubt the existence of the following aggravating factors. It then lists the 5 aggravating factors as it pertains to count 1 of the indictment. Let me scroll down, Mr. Woods, you can see those.
Yes, sir.
1, 2, and 3, and then 4 and 5 are on the next page. I know you're objecting to CCP.
Yes, sir, I maintain that.
Other than that objection, any problems or objections to the language in Section A of the verdict form for count 1?
No, you.
In this verdict form, appropriately in bold below each section, gives the jury instructions on what to do, much like a civil verdict form. It states at the bottom of Section A, if you answer yes to at least one of the aggravating factors listed above, please proceed to Section B. If you answered no to every aggravating factor listed above, do not proceed to Section B. The defendant, James Terry Colley Jr., is not eligible for the death penalty and will be sentenced to life in prison without the possibility of parole. I presume there will be no objection to that language. Correct?
Correct.
Okay. Then we go on to Section B in the event the jury's answering Section B. The question in Section B is reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt in Section A. We, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death, yes or no. Any objection to that question in Section B? All right. Then it has the instruction, if you answered yes to Section B, please proceed to Section C. If you answered no to Section B, do not proceed to Section C. The defendant, James Terry Colley Jr., will be sentenced to life in prison without the possibility of parole. Any objection to that instruction? Right. And we go on to Section C with regards to mitigating circumstances. It's on 2 pages. I'm trying to get all of it on one for you, but it's not working for me on the screen. This is the question. One or more individual jurors find that one or more mitigating circumstance was established by a great degree of the evidence, yes or no? This is a deviation from what the instructions were prior to what the verdict form was prior to May 24th, which had the jury answer as to each mitigating circumstance. So is there any objection from the defense?
I referenced my prior request when we were discussing this issue with regard to Justice Pariente's comment or concurring opinion in the May 24, 2018 opinion, which did modify the existing death penalty jury instructions, as well as the jury form, where Justice Periente recommended for the future that defense attorneys request of the court that the jury be polled as to each individual mitigating circumstance, so that in the event of a death penalty verdict, the court would be able to weigh the various their findings as to the various mitigating circumstances in consideration of the death penalty. We maintain our same position on that. We agree with Justice Periente and would ask that that language, as she had even set out and proposed in that opinion, be included in this verdict form.
State one, have you heard on that, or was the state just asking for the current verdict form?
I understand the defense's argument that this is the standard verdict form, and that would be our recommendation to stick with that.
I do believe that I have the discretion to list out each mitigator and the jury be polled on each mitigator, but I'm not going to exercise that discretion. I am going to follow the form promulgated by the Florida Supreme Court with regards to Section C and the jury's verdict as to mitigating circumstances. The instruction at the bottom of Section C tells the jury to proceed to Section D regardless of your findings in Section C. Section D is eligibility for the death penalty for count one. Reads as follows: we, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt in Section A outweigh the mitigating circumstances established in Section C above. As to count one, first-degree murder, and that is a yes or no. Any objection to that?
Yeah.
Right. And then the instruction for Section D is if you answered yes to Section D, please proceed to Section E. If you answer no to Section D, do not proceed. James Terry Colley will be sentenced to life in prison without the possibility of parole. Then we go to Section E, which is the final section, jury verdict as to the death penalty, which reads as follows: having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt in Section A, that the aggravating factors are sufficient to warrant a sentence of death in Section B, and that the aggravating factors outweigh the mitigating circumstances in Section D. We, the jury, unanimously find that James Terry Colley Jr. should be sentenced to death, yes or no. It then states in the instructions below that if your vote to impose death is less than unanimous, the trial court shall impose a sentence of life without the possibility of parole. The change as of May 24, prior to May 24, the form had the jury state its vote. If it was anything less than unanimous, that's no longer in there. Is there any objection by the defense to the verdict form as it currently reads?
No, you're good. None other than the previous stated on.
Okay, so for the record. And that's the verdict for count one. The verdict for count two is identical with one difference. The only difference is that there are four listed aggravating circumstances rather than five for count two. So any objection to the verdict form for count two other than those previously stated?
No, Your Honor.
If anybody spots any typographical errors, let me know. All right, I think that wraps up the jury instructions. I know I asked you all, maybe it was yesterday, I'm losing track of days at this point, how long you anticipate your closing arguments will last. The state goes first. You only get one closing argument this time, not two. How long do you think your closing argument?
I'm going to say an hour and a half. I don't think it'll be that long, but I'll ask for that amount of time.
How about the defense? How long do you want? I'm not limiting you. Just once you tell me how long, I'll let you.
About that range.
About?
It's, it's hard to. No more than 2 hours. Let's put it on.
Okay. I'll give each side 2 hours then.
Thank you, Judge.
All right. Anything else we need to take up before we break for the day? All right. See you all at 8:45. You want to come in a little earlier and address the CCP tomorrow morning?
That'd be fine. 8:30.
Let's be in at 8:30 and address the CCP issue.
Yes.
That should give us enough time to cover the case.
Thank you, Your Honor.
Thank you. Y'all have a good evening.
I'm doing it for her.